Hello, this is part 5 of the special lecture series on the core competencies for Government 2305 and Government 2306. The core competency to be assessed on Unit Exam 4 is critical thinking. The actual writing prompt you will see on the exam is provided in the Core Competency 4 Instructions and Writing Prompt for Unit Exam 4 document linked just below the link you clicked to open this YouTube video. On Unit Exam 4, students are asked to analyze a decision of the United States Supreme Court. In the Core Competency 4 Instructions and Writing Prompt for Unit Exam 4 document for the Government 2305 course, I've provided the names of 4 cases decided by the U.S. Supreme Court during its 2018 term. Masterpiece Cake Shop Limited versus Colorado Civil Rights Commission, Murphy versus National Collegiate Athletic Association, Minnesota Voters Alliance versus Mansky, and Trump versus Hawaii. Each of these cases raises a specific question or questions related to one of the topics we cover in the Government 2305 course. Among them, religious freedom, freedom of speech, civil rights, and federalism. In the instructions document for Government 2306, I have also provided names of 4 separate cases decided by the United States Supreme Court during its 2018 term. Byrd versus the United States, Collins versus Virginia, Carpenter versus the United States, and McCoy versus Louisiana. Each of these decisions addresses a specific question or questions related to the criminal due process rights that we cover in the Government 2306 course, specifically as they relate to searches and seizures and right to counsel. On Unit Exam 4, one of the 4 cases relative to your course will be randomly selected for you. In Government 2305, that's either Masterpiece Cake Shop, Murphy, Minnesota Voters Alliance, or the Trump case. In Government 2306, that's either the Byrd, Collins, Carpenter, or McCoy case. You will be prompted to write an essay in which you, 1. Discuss the facts of the case. What circumstances unfolded that led to litigation between the parties involved? 2. Identify the question or questions before the court. 3. Determine how the court answered the question or questions before it. 4. Explain the reasoning that led the majority of the court to its decision. What constitutional provisions did the court think were relevant? How did they find these provisions apply to the circumstances of the current case? 5. Were all of the justices in agreement on the court's ruling? Were there concurring opinions? If so, explain the reasoning behind the concurring opinions. Were there dissenting opinions? If so, explain the reasoning behind the dissenting opinions. Number 6, how does the court's ruling in the case square with other case law and principles we have covered in this course this semester? Does the court's ruling affirm or reverse principles we have previously discussed? Explain. To help you sort out how to think about the 5th part of the essay prompt, permit me to digress a bit to say a few words about Supreme Court opinions. As you probably already know, the United States Supreme Court is currently made up of 1 Chief Justice and 8 Associate Justices, when all of the positions are filled under current federal law. The number of justices, however, has not always been set at 9. At various times over the period from 1789, when the Constitution went into effect, to 1869, the court operated with 6, 7, 9, 10, and once again 7 justices. In 1869, Congress set the number at 9, where it has remained ever since. Many of you may remember from your American history course that President Franklin Roosevelt proposed a plan that would have increased the number of justices to as many as 15. That plan was rejected by Congress. However, if you have been paying attention to news reports in the weeks immediately before the 2020 presidential election, you are likely aware that there has been some very recent discussion about whether the number of justices might be increased under a possible Biden presidency. Whatever the total number of justices has been historically, or might be in the future, the point is that, because the court has multiple justices, there will oftentimes be competing interpretations of law by the justices. While many introductory government students are surprised to learn that over 1/3 of all Supreme Court decisions are unanimous, a majority of cases are split decisions, meaning one or more justices has competing interpretations of the law. This fact makes the opinions issued by the justices, that is, the reasoning underlying the votes that they cast in a case, crucially important for us in understanding how the court views important legal and constitutional questions. There are 5 different kinds of opinions you need to be aware of as you read about the cases and prepare to write your essay. In 36% of the cases in which the court's decision is unanimous, the Chief Justice will either himself write the court's opinion or assign the task to an associate justice. The unanimous opinion lays out the legal or constitutional rationale that led the entire court to reach the conclusion it reached in a given case. A famous example of a unanimous opinion of the United States Supreme Court was written by former Chief Justice Earl Warren in the hallowed 1954 decision on Brown versus the Topeka Board of Education. In that opinion, Chief Justice Warren forcefully rejected the doctrine of separate but equal, as it was used to justify racial segregation in public elementary and secondary schools in many states during the middle part of the 20th century. In cases in which there is not a unanimous decision, it may be clear that a majority of the court's justices agreed on the legal or constitutional rationale underlying the majority's conclusion. In a court with 9 justices, the majority may consist of 5, 6, 7, or 8 justices in substantial agreement on legal and constitutional principles. If the Chief Justice is among the majority in agreement, he may write the decision himself or assign the task to one of the associate justices in the majority voting block. The famous case Roe v. Wade was a 7-2 decision of the United States Supreme Court. Chief Justice Warren Burger assigned the majority opinion to Associate Justice Harry Blackmun. In some cases, a majority of the court's justices can agree on the decision, but have diverging rationale for reaching the decision. In such cases, concurring opinions are used by one or more justices to explain why they reached the same conclusions as the majority, but why different reasons led them to the conclusions. Concurring opinions can be important because sometimes the reasons laid out by a justice in a concurring opinion can become the basis for a majority opinion in a subsequent case. For example, the concurring opinion of Associate Justice Louis Brandeis in the 1927 decision on Whitney v. California staunchly defended free speech rights, and it became the basis for the majority opinion 40 years later in Brandenburg v. Ohio. Sometimes, when there is no clear consensus among the justices in the majority as to the rationale, the decision of the court is based on the position in which the members of the majority agreed on, quote, the narrowest possible grounds, unquote. This is known as the Marks Rule, taking its name from the 1977 case Marks versus the United States. In practice, it has been exceedingly difficult for the court to apply this rule, but a good example occurred in the court's 2013 decision in Fisher versus the University of Texas. In that case, the affirmative action admissions policy of the University of Texas was left standing by the court, but in his controlling opinion, Justice Kennedy rejected the Court of Appeals rationale for upholding its constitutional validity on the grounds that the lower court did not apply the strictest standards of judicial scrutiny. As a consequence, the case was sent back to the Fifth Circuit Court of Appeals, which subsequently upheld the University of Texas policy on the grounds that, quote, cannot otherwise achieve diversity, unquote. The case was then appealed to the United States Supreme Court for a second time. The court, after controversial comments by Justice Scalia in oral arguments and his subsequent death before the court's decision in the case, and Justice Kagan recusing herself, held that this time the Fifth Circuit Court had applied correct standards in upholding UT's policy. Often justices who are not in the majority will write one or more dissenting opinions in the case. Dissenting opinions are important because they tend to identify reasons not addressed by the majority opinion. Sometimes dissenting opinions can become the basis of majority opinions in subsequent cases. For example, in response to the unfortunate majority holding in Plessy v. Ferguson in 1896, which sanctioned the doctrine of separate but equal and constitutionally justified 7 decades of continued racial apartheid in the United States, Justice John Marshall Harlan wrote that the Constitution is, quote, colorblind, unquote, and that the 14th Amendment could not tolerate a class system. This, of course, became the basis of the Supreme Court's unanimous opinion in the previously mentioned Brown v. the Topeka Board of Education. To prepare to write your essay, I suggest that you familiarize yourself with each case in the list for your course. The easiest way to do this is by conducting a Google search on each case name relative to your course. Your search on each case will return links to numerous websites or articles that summarize the case. As with everything else on the internet, some sources are better than others. Find a source or call information from several sources sufficient to allow you to address each of the 6 parts of the writing prompt. Those of you who have previously received an index card for Unit Exam 4 from me may use it to write notes about any of the cases listed. Be sure to adhere to the dozen or so criteria outlined in the instructions document. I recommend that you take notes about the information you find from your internet searches on a separate document first. Build into your preparations a sufficient amount of time just to think about these cases and the issues that they raise. This is the part of the preparation process that I think too few students budget sufficient time to. At any rate, after you have thought about these cases, transfer your notes in an orderly manner over to your index card. Consider constructing a table something like the one pictured here to make best use of the limited space you have on that index card. Of course, your notes will be handwritten. I'm always amazed by how much information many of you can squeeze onto that little 3x5 index card. For those of you who did not receive an approved index card from me, please remember that you are not permitted to create your own index card for use on the exam. There is no reason, however, that you cannot go through the same process I just suggested. I think it will likely be very beneficial for you to do so. You simply cannot refer to any of the notes while taking the exam. If you go through the process I have suggested here, though, you may be surprised by how much you recall while writing on the exam, even without the benefit of referring to an index card. Okay, that does it for part 4 of the special lecture series on the core competencies. As always, I view these core competency essays on unit exams as a test of your preparation as much as anything else. You have the writing prompt, you have the case names. Use your time between now and when you take Unit Exam 4 to prepare. Work it all out ahead of time so you don't have to do any deep thinking when you're writing the essay. Being well prepared before you sit down to take the test goes a long way in relieving any anxiety you might otherwise experience while you are taking the test. Good luck.